One of the really fun set of cases to analyze when you are studying constitutional law are the so-called clear and present danger cases, also known as clear and present danger, imminent and lawless action cases. They deal with the question of regulating political speech in crisis times. And they deal with the interest of the government in trying to keep the society secure, try and prevent harm to society, try and promote support for the government, versus the interests of an individual to express dissent, to protest, to challenge the democratically elected government. One of the things that is not clearly understood in telling this story is, until 1925, the First Amendment does not apply to the states. And until, I would say, 1969, the fierce protection of the First Amendment free speech doesn't exist. It's a very young topic when we look at the beginning of the protection of free speech really coming in 1969. And we are dealing with an issue that is changing as I am discussing it with you. When we look at the meaning of the First Amendment, Congress shall make no law abridging freedom of speech. As I mentioned in our earliest toolbox discussions, are we talking about what the author of that language, James Madison, Thomas Jefferson, what did they mean? Are we talking about what the people in the ratifying conventions in different states for the First Amendment, what did they think that meant? Or are we talking about how that wording will change in meaning after the ratification of the 14th Amendment, that now has the possibility of extending the Bill of Rights, the First Amendment, to the states through a long process that we've discussed of incorporation? It's a shifting target that we are talking about. And the question is where to start. And for decades, I would start in the 1919 cases. Schenck, Frohwerk, Debs, Abrams. I would start with Oliver Wendell Holmes and the conversion of his views on how the First Amendment and freedom of speech should be protected, and his alliance with Louis D. Brandeis in trying to create a better protection for the First Amendment 6 years before the First Amendment would be applied to the states. I have now come to a different view, and that's the way I'm going to teach you. I think the story should begin in 1907. Interestingly, it still involves a much younger Oliver Wendell Holmes. Now, when I mean young, you have to understand that he was appointed in the early 1900s to the Supreme Court by Teddy Roosevelt, and he was over 60 years old. He had been on the Massachusetts Supreme Court. He was an old man, even by modern standards, but he was a very old man by 1903 standards. And he would stay on that court until 1930, until he was in his 90s. The Oliver Wendell Holmes that we're talking about in 1907 is a much more conservative Oliver Wendell Holmes than the one we see in the late 1919 cases, the Abrams case. He's a man who is willing to be self-restrained. He is a man who is willing to defer to the state. He is a man who fears disruption of governmental activity, most especially government activity that involves a working courthouse, the actions of a judge. He's a man who is willing to sacrifice individual rights in order to protect those governmental interests. This is the Oliver Wendell Holmes that we saw in the case of Patterson versus Colorado. It's a very unusual case. It involves a newspaper editor who is very unhappy with the positions of a local judge. The local judge seems to be ruling, in the opinion of the editor, seems to be ruling in favor of the Republican Party, seems to be ruling against democratic reforms. And the editor starts to write editorials that are criticizing that judge directly while the judge is ruling in this case. And so the judge decides to cite the editor with criminal contempt. He's going to put him in jail for what he is writing in the newspaper. It's freedom of press. It's also, he claims, freedom of speech. But it's also a sitting judge in a working case being accused of being a partisan Republican by a local editor who, it is said, had more Democratic Party leanings. It's a partisan act. It's harmful to the court. Now, here are the two challenges that Holmes faces. One, he needs to know what the First Amendment means. He needs to look at the history of the First Amendment. But two, he needs to do this and make clear that he's not using the First Amendment at all, because the First Amendment doesn't apply to the states yet. It won't apply until 18 years later in 1925. And so Holmes decides to use the Due Process Clause of the 14th Amendment. I'm going to ask, is this a liberty that the editor has to say what he wants to say about the judge while the trial is underway? But Holmes finesses his opinion in the case by saying, well, which of the rights are we talking about? We're talking about freedom of press, and we're talking about freedom of speech. So I will look at that liberty in the 14th Amendment, and I will try to analyze, what did the framers intend to protect by the wording of the First Amendment? And he does a very familiar history of what free speech and freedom of press looked like in Old England, and comes to the conclusion that there wasn't much free speech and freedom of press, that if you opposed a judge who was acting on behalf of the crown, if you opposed Parliament, if you opposed the king, you were going to be charged with sedition, you were going to be charged with libel, you might be put in jail, you might lose your life. And so his argument in the Patterson case is, what the framers of the First Amendment meant by Congress shall make no law abridging freedom of speech, they meant to ban censorship, prior censorship, known as prior restraints. The First Amendment means no prior restraint. But Holmes then said, when you look at what the great legal theorist Blackstone, William Blackstone, wrote, Blackstone, also a great defender of the First Amendment ideas of free speech and free press, Blackstone comes to the conclusion that while the freedom of press means no prior censorship, no prior restraints, it also allows for the possibility of the government punishing someone after the fact for what they have written or what they have said. So, Blackstone says, no prior restraints is accompanied by, it might be acceptable to have subsequent punishment. And that's the beginning point for Oliver Wendell Holmes. He looks at what this editor has done, and he says, I'm going to approach this not as a prior censorship. He wrote those comments about the judge. I'm going to approach this problem as a subsequent punishment case. After you wrote this, can you be punished? Can you face criminal charges? Can you be put in jail for what you have said? And he needs to explain what is it that the government is trying to protect by jailing this editor. And Holmes's argument is there is a kind of police power that the state has, the ability to protect the health, safety, morals, and public welfare of the society. That ability comes to the states through the 10th Amendment. That ability can be read into the 14th Amendment. And the federalism issues that are involved here allow Holmes to say, I need to characterize what interest the state of Colorado was promoting by putting this fellow in jail for criminal contempt. Excuse me. So his test is, if what you have said or written is, quote, deemed contrary to the public welfare, then it can be punished by the state. And in his opinion, criticizing a sitting judge while a case is underway raises the fear, the possibility that it could undermine the authority of the judge, the support for the judge, the authority of the court, the support for the court, and for the ability of the judge and the court to implement their decisions. He's protecting his own position as Supreme Court Justice by protecting this Colorado State Supreme Court Justice. Holmes's position of total deference to the states, Holmes's position of intolerance for anything that is said or written that is deemed contrary to the public welfare, puts him in the position of supporting the state in regulating the effects of speech, the actions that come from speech after the fact. That is his interpretation of what the First Amendment should have meant if it applied to the states at that time. Now we jump from 1907 to 10 years later, and we're not going to be talking about a Supreme Court case. We're going to be talking about a district court case, and it's not an ordinary district court case. It involves a socialist newspaper, Masses Publisher, and it involves a series of cartoons, and the cartoons criticize the draft, the military draft, in the beginning of World War I. They make fun of the draft, they make fun of the government, they make fun of the people going into the draft and fighting in the war, they make fun of the military and the war effort. It's just cartoons, but it's a protest by the socialist organization through their Masses publication against the work of the military and the government in World War I. The mistake that they make is they send this newspaper out in the mail, and that's a violation of the federal mail power. And so we have the case of Masses Publishing Company versus Patton, who was the publisher, the Postmaster General of the United States Mail. The case is heard by a very young district court judge, very young, very brilliant. His name is Learned Hand. Yes, that's his name, Learned Hand. He and his brother, Augustus Hand, become two of the most famous Court of Appeals judges in American history. Either of them could or should have been appointed to the Supreme Court. They never were. Learned Hand is one of the very much smaller than half a dozen people who are generally agreed as someone who should have been on the Supreme Court but never made it. Learned Hand, I think, is in his late 20s, very early 30s at the time. And he gets this case, and in deciding it, he knows that what he should do is he should use Patterson versus Colorado. He should look to Oliver Wendell Holmes, and he should say, well, it's a question of subsequent punishment. Is it possible that the Masses Publishing Company's cartoons making fun of the military during World War I could be deemed as contrary to the public welfare? Is it possible that the government is right, that people won't go into the draft, that there will be fewer people who are participating in the war effort? Is it possible that these cartoons could single-handedly destroy the war effort of the United States in the early part of World War I? The way I frame this tells you where, in fact, Learned Hand ends up. He decides, I can't follow Oliver Wendell Holmes. It took tremendous courage on Learned Hand's part as a young, ambitious, wanting to be promoted to the Court of Appeals, perhaps wanting to be promoted eventually to the Supreme Court, to criticize a Supreme Court justice, let alone the great Oliver Wendell Holmes. But when he looked at this problem, he looked not at the nature of what the government was claiming would be the problem, contrary to the public welfare, but what the government could prove actually would happen from the cartoons. And he knew the answer was nothing would happen. No one would refuse to go into the draft. No one would undermine the military. World War I would be conducted by the Wilson administration, just as it always wanted to do. There would be no problem from these cartoons. And so he began the argument of this concept of a marketplace of ideas. He began the concept of maybe you have some cartoons that are just designed to make people laugh. Yes, they are produced by a group that the government doesn't like, that is legislated against. They fear them. Yes, you have a federal law, the 1917 Espionage Act, which says you cannot distribute, you cannot pass around official government secrets. You cannot do anything to undermine the military or the draft or the government in times of war. You would be considered to be a spy. He understands that that is, in fact, what the Masses Publishing Company is being accused of. The cartoonists are the same as military spies. But he says, when you put these cartoons out into the marketplace of ideas, those cartoons can be answered by other cartoons. They can be answered by other newspapers. And they can be answered by counter opinion about the benefits of being in World War I. And so he says, you shouldn't be putting people in jail just because you do not like their group, just because you do not like those people, just because you do not like their views. You need to stop, you need to consider their views, and you need, he said, to be tolerant. You need to be tolerant of what they are saying. And you need to ask whether what they are saying has incited a rebellion against the government. So we're looking for tolerance. We're working for the free marketplace of ideas. We're looking for whether or not there has been an incitement from this view in the newspaper. And then he gets to a key point. He says, in order to understand whether there's been incitement, I need for the government to prove to me the actual triggers of action. Show me when people began to follow these cartoons and their views and the socialists and specifically undermine the government. If I don't see those triggers of action, if I don't see that incitement, then I'm going to allow the free marketplace of ideas to operate. Two views: pro-government by Learned Hand, pro-individual protest, pro-government by Oliver Wendell Holmes, pro-individual protest by Learned Hand, and two very different visions of a government with the power to take action against anything that's contrary to the public welfare versus a government that has to wait for a moment, be more tolerant of opposing views, and wait to see actual incitement. You need to protect that ability to speak. So now we get to the 1919 cases.